Good evening, and all of us accept our mutual condolences for the national tragedy which occurred. Uh, and of course, I've also had my own personal sad story. It is not as important as the national one. I'm away, but I just got the news that I have a tiny dog, which I've been taking care of for the past 4 years, which has also died. But as I said, because of the national tragedy, I do not intend to uh, extensively be worried about that because we have human lives which have perished. We entrust their souls into the care of the Almighty God. So, having said that, we welcome you to medical negligence class. We have about 2 or 3 more things to do. So first, we want to discuss medical records or medical expert witnesses and medical reports. We have already seen uh, the elements of medical negligence litigation, but again, when it comes to court, the most important thing is about evidence, as someone will say that the name of the game is what? Evidence. The courts will deal with evidence to find out whether the essential elements of the medical or clinical negligence or malpractice have actually been made up. You've discussed medical records already, so we will not belabor the point. Suffice to remember that medical records is more or less the contemporaneous chronicle. You know, chronicle, that is actually, if you like, keeping a diary of happenings. So, a record which is more or less kept of what happens within the clinical setting. So, therefore, every note, whether handwritten or electronically kept, so long as it captures the patient's histories with respect to diagnosis, doing the investigation to find out what is wrong with the patient, the treatment procedure, and also consent, which you elicit from the patient before the diagnosis, after the diagnosis, the requisite treatment procedure that you intend to deploy. As we know from other areas of medical law, the patient consent will have to be elicited and actually obtained before that can go up. And discussions with respect to follow-up treatments. Now, the documentation of all this, whether in handwriting or electronic, constitute what we call medical records. If you go to many jurisdictions, they have actually transitioned into digital or electronic record keeping. Now, here in Ghana, our checks indicate that the Ministry of Health, I think in conjunction with other agencies, have had what we call the electronic medical records projects. And the idea is to actually rule out the digital keeping of medical records, which is a very good thing because, as we know, once records are kept, electronically, it becomes easy for retrieval and access wherever it may be necessary to actually attend to the medical history of a particular patient. Particularly so, where the patient, for example, goes to another facility other than his or her regular facility. So, assuming you have a system which ensures that there's that kind of what do you call the interface and the necessary links between the various facilities. If, for example, you are at Kuntanase and you happen to go to Kasoa and you need a treatment, it will just be a question of entering your patient ID or some other information, and all your records, your medical history, everything which are held electronically will come up. Yeah, so I think that is one of the overriding utility of uh, having electronic keeping of medical records. And as you notice, the projects and in some even private facilities, in some government is done. You move beyond the piloting stage to actually integration of it into everyday, if you like, clinical experience. And it extends even to like laboratory fits, so that where labs are conducted, you don't need to have the handwritten or the printed result from the lab. It will be fed or uploaded into the requisite portal. And then the clinicians, the physicians sitting in the various consulting rooms can just access it without having to touch any paper. And the same thing applies to imaging, as well as even like the pharmacy logs. And pharmacy logs, very important. What drugs did the doctor prescribe should be dispensed to the patient in terms of the quantity, the dosage, and so on. So where you have electronic records of this, it becomes easier for audit roles to be done should anything go wrong, or should a new physician even take over the case of a particular patient. So we cannot belabor the significance of having electronic version of medical records. We have also noted from our previous subjects related to what we are discussing that when it comes to medical records, it's within the domain of right to access to information. So you, as a patient, you have the right to information about yourself. And uh, there's a background. We've told you before, the case of Elizabeth Vaah against Lister Hospital, which you've read last semester, where there was that kind of controversy between the facility and the patient who had undergone this IVF form of treatment, and something had gone wrong and needed a medical record so that if she traveled abroad, he could show it to the medical team. And then the hospital was not very cooperative. And it got to a point that the patient family even had to involve the media. And that actually escalated it, making the facility angry, because the facility wanted to avoid public attention for being in the news for wrong reasons. So it took intervention of lawyers to go to court for the court to order the hospital to make available the records as it were, but that shouldn't be. Now, if you take you have the Right to Information Act, for example, and we don't need to belabor the point as to whether a person can actually make a demand for his medical records to be released. If you look at the Elizabeth Vaah against Lister, there was this concern that if the courts did what they did, it was going to open the floodgates for people to be demanding their medical records, and then it will become burdensome for facilities. I mean, that is no longer necessary. It's a moot point now. The point is quite moot, having regard to even the passage of the Right to Information Act and the Data Protection Act, as it were. Yeah, so you have done medical records, so that is not our real focus in this particular session. Our real focus is on the experts, testimony or expert reports, and this relationship to medical negligence. So that is what we want to look at. So this one is just um, if you like, trying to revise what we know already. So you, the patient, you can request, and should you even die, your next of kin or your personal representative can also request. And let me say a few words here, especially the lawyers who may want to take up medical negligence cases. Very soon, we make the point that you need to gather your evidence, and your evidence will definitely include the medical records. Now, your patient is dead, right? The rare victim of medical negligence is disease. So, how do you get access to the records? You need to, first of all, regularize the status of those who came for you. If they're the personal representatives, either they have the probate or the letters of administration, and on basis of that, you are able to write to the facility for them to release the information to you as it were. Okay, so as I said, our main focus is on the expert witnesses. Uh, Expert witnesses are very important when it comes to medical negligence litigation. So we like to know who is an expert witness, what makes them special, and why are they important in medical negligence litigation. So first, the Evidence Act. If you look at the Evidence Act, what I've done is at the end of this teaching notes, I have put the details of the relevant legislations and materials I've assessed at the bottom for you so that you can just read from there if you don't want to go and look for the provisions. So if you look at the Evidence Act, the starting point is that every person is a competent witness. Every person is a competent witness. That is, any person who is a compos mentis or sound mind, so long as the person is able to communicate, that is able to express his thought to be comprehensible, to be understood, and is able to appreciate the duty to tell the truth. So if you are able to appreciate the duty to tell the truth in the sense that you are going to take oath, oaths are not taken for fun. Then again, the testimony, what you are going to speak to, must be based on your personal knowledge. So if what you are going to speak to is based upon your personal knowledge, that is something that you know because you've used your own senses as a human being to experience them, then you can speak to that, then you are a competent witness. In that case, you are just what we call a lay witness. A lay witness in the sense that you are not, if you like, making claim to anything beyond what your own senses enable you to experience. So you are a competent witness and a lay witness. That's a non-expert witness. On the other hand, you may not have had a personal knowledge of whatever you are going to testify or speak to, in which case you are treated as an expert. Expert. So I have reproduced like the red definition of an expert for you, the text of the law at the bottom of the notes for you. So the most important thing is that as an expert, the basis of your testimony in the court is more of the special skill which you have, the professional experience or training relevant to the particular issue in controversy. So how do we establish? Of course, your CV and certifications will speak to the experience or the skills that you have. And sometimes your publications or maybe peer standing by your peers in the field, they will all help you to make the case that you are an expert. And for that matter, you're able to provide an expert testimony in respect of an issue in controversy. So let's keep that in mind. Now, where you are not an expert, then if you look at the evidence law, particularly you look at section 111 to 115, you will notice that in terms of the scope of your testimony, you are limited. You are limited in the sense that you can only testify about matters which are within common experience of human beings. Matters within common experience of human beings, matters that you are able to bear a personal knowledge, a personal experience using your senses, your eye, your ear, your nose, your mouth, your hands, as it were. These are your senses. These are the senses you use to experience or encounter something. So the information, which deployment of these senses of yours with respect to a particular matter in issue, you will be able to testify as a non-expert. However, there are situations in which we have complicated matters. Complicated matters in the sense that they are beyond common experience of human beings. And for that matter, it may be necessary for the person going to speak to those matters to speak from information or evidence which may otherwise even be inadmissible, in the sense that they have the potential to traverse the ultimate issues on which the controversy or the dispute turns. So this is where expert witness become important. In relation to medical negligence, for example, let's suppose that there's an issue as to whether a particular drug which was taken can actually give rise to maybe let me use the example of my dog. I have a dog called Cindy which died, and it's this Maltese, those tiny dogs with a lot of you know hair, like the teddy bear type. You know what I'm talking about. So few days ago, it's part of grooming, but I'm sure they overdid it and more or less removed everything so to the skin. And it appears that the weather has become cold, of late. So we haven't done postmortem, but from a layman point of view, I suspect that it might have died from, let's say, pneumonia, sort of. I'm sure dogs too can suffer pneumonia. So let's assume that we are trying to hold someone liable for having been responsible for the death of the dog. And let's say that the person who did the grooming or cutting the hair. Now, as a lay person, apart from you witnessing the fact that you saw the person cutting the hair, that's what you can speak to. You will not be allowed to, say that where you cut significant amount of the hair of those type of those species of dog, and the temperatures fall, and they are not given maybe some special warm clothing and so on, it can lead to their death. You, a layperson, would not be allowed to give such an opinion, to give such a testimony. But if we have, let's say, a veterinarian, you have a veterinary doctor or veterinary surgeon, he or she, by reason of his expertise, will be allowed to give an opinion in respect of matters like this, which exceed our common experience as human beings. So that is how expert opinion becomes important. Now, with respect to experts, they can be appointed in one of two ways. The court on its own can appoint an expert in the course of litigation, in which case you have what you call the court-appointed experts, court witness, as it were, court-appointed experts. Or one of the parties or both parties may even choose their expert to come and speak to their theory or their version of the case. So if you look at Section 114 of the Evidence Act and even Order 26 of the High Court Civil Procedure Rule CI 47, they all create the framework for such appointment. So the court may appoint an independent expert. Independent expert in the sense that the expert is not nominated by the parties or by a party. It's the court which has actually nominated the particular expert. And where the expert has been so appointed, the expert will make its report available to the court, first through the registrar of the court. And once it is so made available to the registrar of the court, the registrar will also circulate or share the report with the parties. And because the expert was appointed to do a work related to a pending matter before the court, when the matter is called, the expert will have to enter the witness box, take a note, and formally tender his report, which is his evidence in chief, as it were, in the court. And then once that has been done, cross-examination will be done by the parties. So in that case, each of the parties have the right to do cross-examination. So let us keep that in mind. Although previously, the position of the laws used to be that once the expert report has been submitted to the registrar, then if you wanted to cross-examine the expert, you had to take steps within 14 days. Now, that rule is not necessarily cast in stone now in view of some Supreme Court decision, taking us back to the Evidence Act, which says that evidence objections may be attended when an evidence is offered. And then the crucial question is, when is evidence offered? Evidence is offered in the course of the trial, not outside the trial. So therefore, when the expert has been appointed, quite apart from the fact that the expert will send the report to the registrar, the expert will still have to be called before the court and actually tender the report before the parties who are interested in cross-examining may actually cross-examine. Now, quite apart from the court, of course, let me say that, so who pays for the fee of the experts? Experts are entitled to fee for their professional services. Now, even where the expert is a court-appointed expert, since the work of the expert is ultimately going to benefit the litigants will have to bear the cost. So usually it is shared equally between the parties. So that is how it is. And that is why both sides of the matter reserve the right to cross-examine the experts. Then again, apart from the courts appointing the experts, it is also permissible for a party to the dispute or the suit to appoint his or her own expert. So that let's say that if you are the plaintiff, right, the plaintiff or the claimant, you need to get your experts. You are the defendant. You need to get your expert. And I must say that when it comes to medical negligence, because almost all the time, the defendants will be the technical side, because the defendants usually the healthcare professional and then the facility that he or she works for. So these are already the technical people. And you, the claimant or the plaintiff, the victim of the alleged medical malpractice or negligence, you are not an expert. And for that matter, it may be necessary for your lawyer, as part of preparing for the case, to also arrange and get an expert who will come and testify in order to explain your side of the case to the court from a technical point of view. And that is very important. And where you want to appoint an expert on your own, you don't need to get permission or the leave of the court. Just as you call any witness, you can also call your expert a witness. So that is one. And then there's expert witness may also be called either by ordinary invitation or by summons of the court, in which case you get the subpoena ad tecum or subpoena ad testificandum. That is a summons for him to come and testify or to tender a document issued. And of course, where subpoena is actually served, if you disregard it, automatically you become a candidate for contempt of court proceedings. But then, where you are being called not per subpoena, but just an ordinary invitation, in that case, you can decide whether to come or not to come. So that is what usually happens for a lot of medical negligence litigants in Ghana. They approach a prospective expert who is like a doctor or a health expert, and the person does not want to appear to have actually exposed the errors by his colleague. So they may be hesitant in actually coming. So those are some of the things let's keep in mind. But you don't, before you actually think of calling an expert, you must start engaging the expert and let the expert know your case. And then you listen to the expert's assessment. The expert is supposed to be a technical person, so he's supposed to be honest. And from his technical point of view, tell you what ought to have been done or what ought not to have been done. And then that will help you to actually make your own assessment as to whether the evidence of that expert will assist in building your case in court. So let's keep that in mind. Now, talking about experts, the issue also come up. Uh, must experts always submit a report? The answer is yes and no. Yes, where the expert, for example, has been appointed by the court. So you have your terms of reference. The court will give you terms of reference, and you're supposed to do your report and submit it. Or where you're being called by a party, not through subpoena, but this one you're being called by a party uh, as a normal, witness. You can do your technical report, and when you do, of course, if you look at the current dispensation, CI 87, which amends CI 47, with the introduction of what they call the witness statements. The idea is to make trial faster. So instead of like the witness coming to enter the box and narrate his long story in the examination in chief or the oral examination in chief, you rather get the witness to reduce the story in writing so that when he or she mounts the boss, after being sworn, he or she will be led to identify and confirm the particular statement that he made. And then once so identified and confirmed, the court would adopt it and consider it as his evidence in chief, and then he will be made available for cross-examination by the opposing party. Now, where you are an expert or you are calling an expert witness and is doing a report, you have to remind him in his report to include his qualifications. And qualifications are very important now. These days, you see how people have been exposed for having arrogated to themselves certain titles. So if you say you have like a certain qualification, you have to note that in a court of law, it is purely adversarial. Adversarial in the sense that everything is contested. And because everything is contested, and then when you are witness, it's not only what you are saying which is of interest to the court and to the other party. We're interested in the message as well as the messenger. What do you mean by that? The messenger is the witness. We are interested in your truthfulness, your credibility. Do you have the traits of telling the truth, of being honest, of saying it as it is? So we are interested in that. Now, if we are able to satisfy ourselves that you are not a witness who is credible and you contradict yourself so much that everything points to the fact that you are a liar, you are economical with the truth. In that case, regardless of how sweet the story you have told is, we may not, attach significant value or weight to your testimony. So, if, for example, you are an expert witness and you claim to have a certain qualification, and let me make this point clear. As an expert witness, the expert opinion you are going to give is value, is quality, is a function of the expertise you profess to have. And that is why your qualification is important. So therefore, if you claim to have a certain certification and that certification is not true, or the certification is by even a dodgy institution, with the dodgy accreditation, credentials and so on, then it may affect how serious the court will take your expert opinion. And that is why the qualification is important. And then if the expert is also a professional, it is also useful for you to ensure that the expert is actually uh, compliant with the industry trend and requirements. Let's say you're an engineer. Are you an engineer in good standing? If you're supposed to do some continuous professional development, have you done that? A medical doctor, have you done your requisite CPD? Have you renewed your license and all those? Because you're going to testify and then your license is not even renewed, then they raise the question mark as whether your knowledge and your expertise have been validated by regulators and then the industry standards. And of course, you are going to do a report, an expert report. It will also be necessary to have the instruction that the commission party asks me the following questions or this and that. You can line them or list them. Then when you finish, you go ahead and provide your responses. And then again, of course, you provide the material you relied on. And we are also interested in the reasoning you did and the conclusions that you've arrived at. Because that is very important. That is what will help the court to take your report serious or not. In any case, your expert opinion is not binding on the court, but the court needs to be persuaded by it, and its persuasiveness is very much dependent upon how credible it is. Now, you remember the case of Bolam and Bolaito. Bolam doctrine was to the effect that if the defendant healthcare professional will get a group of other professionals who come and take an oath, testify and say that they will have conducted themselves in the same way that this particular defendant healthcare professional did, then according to the reasoning in Bolam, that healthcare professional who have been exculpated from liability will not be held liable for the supposed medical negligence. Now, as we saw, Bolaito came to say that it is not enough for a body of medical opinion to say that they would have done what the defendant did or they wouldn't have done what they did. We have to subject what they are saying to straight logical analysis and find out whether there's a logical consistency. And this means that syllogism becomes important. We have premise and conclusion. Premise and conclusion simply means that you are saying that if it was this, then that. So we need to find out the conclusion that you are arriving at. Does it flow reasonably from the two premises, the premises that you have set up? And for that matter, if we look at the information or the other things before you, and you disregarding that and jumping to a conclusion, that conclusion may not be sustainable because of the logical deficit. So that is very important. And again, another quality marker of the expert report is being candid. Being candid in the sense that say it as it is. You must discuss contrary views. Maybe the particular thing that you are testifying about, there may be a competing views, there are different schools of thought, and your position happen to be one of the competing schools of thought. You have to be candid and let your report reflect that, and then try to justify why you think that your preferred view is the better one, having already acknowledged and made your report reflect the other positions which are contrary to yours. So that way, you are bringing yourself within the spirit of Bolito, because the court will have to, critically and logically, critique or review what you are doing. Again, the report should be in plain English. You are an expert. You don't achieve any purpose if you go and sign the witness box and you are saying huge technical things without making an effort to break it down into a plain English. Mind you, the judge or the jury, as the case may be, these are not experts. Expert in the sense that they are not coming from a particular expert background that you are speaking from. And they are supposed to understand what you are saying so that they'll be able to, the judge or the jury will be able to come to a decision at the end of the day. So where your expert report was done without any effort to actually break it down for the court to understand, you would not have actually achieved anything. So it's not a time to show off. It's a time to be comprehensible, to be understood, as it were. So let's keep that in mind. But if you have, maybe sometimes you can commission, two different experts, as it were, and you can bring them together so that if there are some differences regarding the approaches that they are using, they will be able to synchronize their position and have that. Somebody said, I've just been able to enter. Oh, sorry. I'm sure the recording is there. You can play it back. Yeah, so this will mark the end of our first